Part of the Karen Reed civil case has been moved to federal court. How and what does it mean? May it please the audience, I'm Rich Schoenstein. Welcome to So Sue Me. Last time we were together before the Thanksgiving holiday, and by the way, happy Thanksgiving. Hope everyone enjoyed the weekend. But last time out, we talked about the Karen Reed civil litigation and how there are two cases pending in state court. And then, right before the holiday, one of those cases was moved to federal court, or I should say removed to federal court, because that's the technical term when you take a case that is pending in state court and you move it to federal court. And I want to talk about why that happened, how it happened, and what it means in this particular case. All right. So let's talk about state and federal court jurisdiction very briefly. I know this is going to be scintillating for a lot of you, but civil cases can indeed be brought in federal court. There are traditionally two different bases of jurisdiction for a civil case to go to federal court. First is what we call federal question jurisdiction, or 28 U.S. Code Section 1331. And that just says that district courts, meaning federal district courts, have original jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. So any civil case brought under federal law can go to federal court under what we call federal question jurisdiction. And this is the basis of removing the Karen Reed case at issue to federal court. As we're going to see, there are claims brought under federal law, and therefore they're appropriate to federal court. Now, there is also a basis for federal jurisdiction called diversity of citizenship. And this is true when there are parties in the case, the plaintiff and the defendant, from different states, and the amount in controversy exceeds $75,000. And in those cases, too, the defendants can remove the case. Actually, the plaintiff can bring the case in federal court, or if the plaintiff brings the case in state court, a defendant can remove it to federal court and say, no, it belongs here. But for diversity of citizenship, all of the plaintiffs need to be from different states than all of the defendants. If there's even one crossover, one plaintiff and one defendant are from the same state, it can't go to federal court under this ground. So here's the notice of removal that was filed by Karen Reed's legal team last week. Notice of removal of action to federal court. This is the action that Karen Reed brought asserting violations of her rights by the law enforcement defendants Proctor, Buchanan, and Tully, and by certain people who were in the house inside where John O'Keefe was found dead. And that's Brian Tully, Brian Albert, Nicole Albert, Jennifer McCabe, Matthew McCabe, and Brian Higgins, the house defendants, as they have been called. And so there's a notice of removal that's filed in the state court telling the state court that this case has been removed to federal court. And then there's a civil cover sheet. That's a document that's filed in the federal court action, commencing the action in federal court. And you'll see where it says basis of jurisdiction in Section 2, it's talking about federal question jurisdiction. And then it attaches a notice of removal. You don't typically have to say a lot in the notice of removal. This one is a little bit verbose about why it's being brought. But essentially, it's saying that this is a civil action. The court has original jurisdiction because there are federal civil rights claims. There's a claim under 42 U.S.C. 1983, conspiracy to deprive Ms. Reed of her Fourth Amendment rights. That is brought under federal law. There's another claim brought under the Fourth Amendment of the United States Constitution. And because those claims are brought under federal law, this case is appropriately brought in federal court. And then the notice of removal attaches the actual complaint that was sent so that the federal court can see whether or not they think jurisdiction is appropriate. And if you just scroll down here to the causes of action. You see very clearly there's count 1 asserted under federal law, says so right in the heading. Count 2 asserted under federal law. Count 3 asserted under federal law. Count 4 is a Massachusetts Civil Rights Act claim, but that's okay if there are federal causes of action. The federal court can also hear the state causes of action. Thus, it appears perfectly appropriate that this case has been removed to federal court. There are federal claims. It does have federal question jurisdiction. The case could have been filed initially in federal court, so it is proper for one or more of the defendants to remove it to federal court. Now, if the plaintiff wants to challenge that, they can do so. They can bring something called a motion for remand in the federal court. They can say to the federal court, this doesn't belong here, and therefore you should return it to state court. Another thing they could do potentially is they could drop all of the federal causes of action. The plaintiff could turn around and say, all right, we're not going to bring claims under federal law. We're going to drop our claim under the Constitution. We're restoring this complaint so that it only has state law claims, and therefore there is no more federal jurisdiction. I don't know whether or not Karen Reed's team is going to do that, but that is one of their options. So I went and checked this out on Pacer. That's the website with the federal court docket, and you can see this case has actually been now moved to the District of Massachusetts in Boston, assigned to Chief District Judge Denise Casper. And you can see there's already attorneys listed both for the plaintiff, Karen Reed, and then for certain of the defendants, Cabe, Albert Higgins, have attorneys listed. And then the docket has just a few entries, including the notice of removal and notices of appearance by some of the attorneys representing the plaintiff, Karen Reed. We don't yet know what the response will be in federal court. I practice in New York, not Massachusetts, so I'm not familiar with the judge, but here she is, Denise Cooper, born 1968. This is Chief United States District Judge of the United States District Court for the District of Massachusetts. She used to be a district attorney in the Middlesex office in Cambridge, Massachusetts. She oversaw the criminal trial of Whitey Bulger. She is an Obama appointee. She's a graduate of Wesleyan University and has a JD from Harvard Law School. So I don't know her, and I frankly don't know anything about her reputation, but she's obviously a very well-qualified judge. All right, having said all of that, why would you remove a case from state court to federal court? And I want to talk about it generally speaking, and then I want to talk about it in the context of the Karen Reed case. Generally speaking, why would you want to be in federal court instead of state court? Well, don't tell any state judges I said this, but federal court is better. Federal court is better funded. They have nicer courtrooms. The judges tend to be a little bit better, a little bit more qualified. The cases move faster. The federal courts tend to be a little bit tighter about discovery. They don't allow discovery to go on as long and as broadly. They tend to keep it contained a little more. And they just run more efficiently towards a result. So if you're interested in getting your case to a result promptly, you would rather go to federal court. If you're concerned about state court bias, you would rather go to federal court, but I don't think that's the case here because everybody involved is from Massachusetts. Karen Reed's from Massachusetts. The defendants are from Massachusetts. I don't think state court bias has anything to do with it. You generally get a better jury pool, a slightly more well-educated jury pool, more professional-oriented jury pool in federal court. And if you're thinking ahead to the quality of the adjudication at trial, you might want to go to federal court. It's just generally better. It is faster, it is smarter, it is more efficient, and the decision-making is a little bit better. That's why you might want to go to federal court. Now, if you're representing the defendants in this case, the law enforcement defendants and the House defendants, why would you want to move this particular case to federal court. And what's interesting here, right, is there are multiple cases. There were 2 cases pending in state court. One is the case by the O'Keefe family against Karen Reed and the bars that were serving everybody that night. That's a wrongful death cause of action, and that's pending in state court separately. And that case has not been removed. That case is still going to proceed in state court. And the last time there was a hearing on that case, the suggestion was that these 2 cases were going to be joined for pretrial discovery, but that's not going to happen if you have one case in state court and one case in federal court. So why would the defendants want to move one of the 2 cases to federal court? Those defendants, the House defendants and the law enforcement defendants, are not parties in the wrongful death action. So they're not necessarily litigating in 2 separate forms, although they'll be witnesses for sure in the wrongful death case because they're going to get called for deposition and trial testimony by one or both sides. But maybe the House defendants want to put their case in federal court so they can proceed quicker and more efficiently than the wrongful death case. Maybe they want to do that and move that case more promptly. Maybe they think it puts some pressure on Karen Reed because in federal court, she may have to get deposed first, among other things. It also provides an opportunity for those defendants who have been threatening to bring claims of their own against Karen Reed. They can now bring those claims in federal court because they can bring counterclaims, whether they're federal or state, in the proceeding that has now been removed to federal court. If they're really going to pursue defamation claims, as they have said, they could now have those claims in federal court, which they might think is strategically advantageous. And that's one of the reasons that Karen Reed's team might consider dropping the federal claims so they can get out of federal court. Civil litigation is a chess match back and forth. There are so many of these moves and counter moves in pleadings, in discovery, in motion practice, before these cases ever get to trial. And so what we're seeing now is opening moves. Opening move by the O'Keefes, sue for wrongful death. Opening move by Karen Reed, sue the House defendants and the law enforcement defendants for violation of her rights. Opening move of those defendants is to bring that case to federal court. Watching the subsequent moves as they play out back and forth is going to be just fascinating. Now, it may also be the case that the defense team thinks federal court will be a better place to contain Karen Reed and her counsel. Her counsel is very aggressive, and the defense team may feel like a federal judge will give them less leeway, less room to roam, less rope, so to speak, in federal court than they would get in state court. That would be another reason for this particular case to be moved to federal court. Also, and I should add this is really important, there are not typically cameras in federal courtrooms. So while the proceedings in state court, certainly the criminal proceedings, were televised, it's possible that a federal court proceeding in Massachusetts would not be televised, and there would be no video in there. And maybe the people who move the case from state court to federal court are doing so in part to avoid additional public scrutiny of everything that went on, or just to avoid being on television. Maybe they want their case decided in a court of law and not in the court of public opinion. That could be more of the kind of thinking. It's sort of speculative because one or all or any mix of these factors could lead the parties to conclude that federal court is better. Maybe they didn't like the judge that was assigned to them in state court. Maybe they didn't like that particular venue of state court that Karen Reed selected. There are so many different reasons to move the case to federal court, but for some mix of them or some of them, they have done so. What will happen next? Don't know. As I said, this is sort of a chess match back and forth, and it's not really just two-sided because in this case, there are really 3 sets of parties and 2 different cases. There's the O'Keefe plaintiffs. There's Karen Reed as a defendant. There's Karen Reed as a plaintiff. And there's this group of House defendants and law enforcement defendants, some of whom may also bring claims of their own. It makes it very complicated. And now you have proceedings in two different courts in different jurisdictions, one in state, one in federal court, all of which is going to proceed at some pace. And as a general matter, these courts don't care so much that there's another case proceeding in another court. They're going to set their own schedule, and they're going to move forward on a schedule that they think is just and proper for the case in front of them, even if there's some other civil proceeding somewhere else. So that's where we are. Removal of the federal court, federal question jurisdiction. This is not a matter of diversity jurisdiction. We get a little bit of civil procedure here on an early episode of So Sue Me. Thank you again for joining us. We'll be back to see you soon. For now, we are adjourned.